Hi there. I'm Dr. Suzanne Bechtel, a passionate legal educator dedicated to making legal studies clear, practical, and even a little inspiring. On this channel, you'll find a growing collection of videos designed to help you prepare for the Certified Paralegal exam. It covers key topics, breaking down complex concepts, and offering study tips that actually stick. If you're looking for a deeper dive, check out my Teachable School, where I offer structured courses, interactive tools, and exclusive resources to support your journey towards certification. Watch this video to the end and you'll find a coupon code for a discount. Don't forget to subscribe and explore the playlists. Your success on the NALA CP exam starts here. Now, before we move on to the lecture, there are two important disclaimers. First of all, this is not considered legal advice. Everything shared here is designed to support your learning journey. Also, I am not a lawyer. This course is designed to help you understand the concepts of the exam. Thank you.
Hello, Dr. Suzanne Bechtel here, and our lecture now is in the contract law playlist, and we're going to talk about remedies for breach of contract, what kinds of legal solutions there are for contract breaches and violations. We will see an overview in a minute, along with legal remedies, including and we'll talk about the legal remedies and equitable remedies, and talk also about quasi-contractual remedies and the effect of waivers. All right, an overview. When a party breaches, the other party may sue for breach of contract to enforce their rights. And then there are legal remedies, and those are the type of remedies that typically include monetary damages to compensate the injured parties for losses caused by the breach. When we're talking about equitable remedies, we are dealing with court orders such as injunctions or specific performance to enforce contract terms. So that's what happens. Those are the large scale, the 10,000 foot view of what happens when a party breaches a contract. So let's look next to legal remedies for a breach of contract, and remembering that legal remedies are monetary awards. Monetary awards will compensate the injured party for losses caused by a breach or wrongdoing. Compensatory damages aim to restore the injured party to their original place where they were originally. Missing a word on that slide. Compensatory damages, and they are the most frequently awarded type of damages in legal disputes. Punitive damages are when the breach is accompanied by an independent tort involving fraud, malice, oppression, or reckless disregard for rights. So it comes into play in these areas. I should also add corporate policy is another classic trigger. So malice, fraud, corporate policy come into play when punitive awards are given by the court. One scenario would be a contract case with the fraudulent insurance adjuster. So Ms. Carter, she purchases a commercial insurance policy from an insurance company. We'll call it Harbor Point. And the policy promises coverage for fire damage up to $500,000. And when a fire breaks out in her bakery and extensive damage is incurred, she files a claim. Now, Mr. Lang, he is an insurance adjuster, and he is pressured by his regional manager to reduce payouts and improve the quarterly numbers. So during the investigation, Mr. Lang discovers the fire was accidental, the loss is fully covered and the damages clearly exceed $300,000. Instead of honoring the policy, he intentionally alters some internal reports to make the damage appear minimal and tells Ms. Carter that her policy doesn't cover electrical fires, which is false. He also threatens Ms. Carter that if she challenges the denial, her premiums will triple next year. So he offers her $20,000, labeling it a goodwill settlement if she signs the release immediately. So she's suspicious and hires a lawyer, and in discovery, after filing a lawsuit, in discovery, the information reveals emails that Mr. Lang knowingly falsified documents, and at Harbor Point, the insurance company had a company-wide practice of denying valid claims to reduce payouts. So the legal outcome is the insurer's refusal to pay is a breach of contract, but the intentional fraud, coercion, and bad faith claims, handling of bad faith claims, constitute an independent tort. And because his conduct was willful, malicious, and part of a systemic scheme, and the court allows punitive damages to punish and deter the misconduct. So as you can see in a case like this, punitive damages were awarded not for the breach itself, but for the tortious, fraudulent behavior intertwined with the breach. So it shows, the scenario shows the general rule that punitive damages are not available for ordinary breach, and that there is an exception, and that punitive damages are available when the breach is accompanied by an independent tort. Another example, because of, I wanted to find an example for the corporate policy issue. Kind of like it resembles the insurance thing, but corporate policy, so, maybe Safe Harbor has a delay and deny policy, Safe Harbor Insurance. So it markets itself as a consumer-friendly insurer. Internally, though, it's a different story. The company has adopted a secret corporate policy called the Delay and Deny Protocol. And the policy circulated through training manuals and manager emails, and these things direct all adjusters to automatically deny all first-time medical claims, regardless of their merit, and delay legitimate claims for at least 90 days to discourage persistence, offer lowball settlements to seriously ill claimants, and tie employee bonuses to the percentage of claims denied and not accuracy. So what happens is a policyholder, and this time Mr. Lewis, undergoes emergency heart surgery, and his doctor submits a claim for $68,000, and fully covered under the policy. And Safe Harbor denies the claim and doesn't even review it, sends a form letter stating procedure was an elective, ignores multiple appeals, offers a courtesy settlement of $5,000 if he signs a release, and poor Mr. Lewis suffers severe financial strain. His savings are drained. He nearly loses his home. And during litigation, the internal documents at the Safety Harbor, whatever that insurance name is, internal documents surfaced showing that Safe Harbor's executives knew the policy was unlawful and intentionally designed to reduce payouts by 22% annually. So, hypothetically, we could say that the wrongful denial is a breach of contract, but the corporate policy of systematically denying valid claims constitutes fraud, bad faith, and malicious conduct, and that it was intentional, profit-driven, and company-wide. It wasn't simply an isolated mistake. And because the misconduct stems from corporate policy, not just some rogue employee, the court awards punitive damages to punish the insurer and deter similar practices. So in this kind of situation, Mr. Lewis, a poor man, could receive compensatory damages for the unpaid claim and financial losses, and the court could award substantial punitive damages due to their deliberate systemic wrongdoing. And the judge would cite to the need to deter insurers from adopting policies that weaponize bureaucracy against vulnerable policy holders. So see here the difference between individual misconduct and corporate level malice. So we've seen this situation where the first case scenario was about an individual misconduct, but then we have the corporate level malice. And these are good demonstrations of why punitive damages can be appropriate when a company institutionalizes harmful behavior or has rogue employees that do bad things. Next, we'll look at consequential damages. And consequential damages are monetary awards exceeding compensatory damages due to special circumstances or expenses. The promisee must inform the promisor of unusual potential consequences at contract formation to be able to claim consequential damages. So a scenario for this one, the broken commercial freezer, where a small seafood restaurant, Blue Wave Grill, orders a commercial freezer from Arctic Pro Appliances. And the restaurant tells the sales rep, "We need this freezer installed by Friday because we have $12,000 worth of fresh seafood arriving Saturday morning. If the freezer isn't working, the shipment will spoil." So Arctic Pro makes the promise that delivery and installation will be done by Friday. But the freezer arrives late, it's installed incorrectly, and the shipment of seafood arrives, and lo and behold, the freezer isn't operational, and by Monday morning, the food has spoiled. So the Blue Wave restaurant has experienced losses in the form of direct damages, which would include the cost of the freezer because it was defective and improperly installed, and consequential damages, the $12,000 in spoiled food, also lost weekend revenue from the menu items that couldn't be served. They had to replace the seafood, and that it was an emergency ended up being higher prices. And these losses were foreseeable. Foreseeability is essential because they explicitly warned Arctic Pro that timely installation was essential to prevent the spoilage. So because Arctic Pro knew, or reasonably should have known, that delay would cause spoilage and lost profits, the restaurant can recover the consequential damages in addition to direct damages that happened as a result of the defective installation. Then damages that naturally arise from the breach, plus damages that were reasonably foreseeable at the time of the contracting. So note here that you can see here a direct separation of direct losses versus consequential losses, and don't forget that element of foreseeability. That requirement is still there. All right, next we'll go into liquidated damages. These are pre-agreed amounts payable upon contract breach, and they're used as a way of simplifying damage assessments and providing certainty. So let's say a sales contract for a custom-built espresso machine is ordered by a specialty coffee shop, and this time we'll call them Harbor Roasters, and they contract with Precision Brewtech, a manufacturer of custom commercial espresso machines. And Harbor Roasters orders a machine with unique specs, such as a dual boiler system, custom copper housing, some digital integrated digital pressure profiling. The list goes on. They wanted some customization. And they had a delivery deadline. Their grand opening is on June 5th, and they need that delivered by June 1st. And notice that because it's customized and custom built, Brewtech, the manufacturer, cannot easily resell it if the buyer backs out. And so they add a liquidated damages clause to their sales contract. And it might say something like, if buyer cancels this order after production has begun, buyer shall pay the seller $8,000 as liquidated damages, and that amount representing the seller's anticipated losses due to the custom nature of the machine and their difficulty reselling it. And so both parties agree the actual damages would be hard to calculate. It's an important factor, and that $8,000 is a reasonable estimate of the lost materials, labor, and resale difficulty. All right, so 2 weeks before delivery, Harbor Roasters cancels the order because they found a cheaper supplier. But Brewtech had already begun fabrication of the system and put together some of the specialty components. And they've incurred so far $6,500 in labor and materials. And so now they've even lost a production slot that they would have had for another customer. So Brewtech invokes the liquidated damages clause and demands $8,000 from Harbor Roasters, who refuses, arguing that Brewtech should prove actual damages. So this would likely be enforced by the court. The liquidated damages clause would be because the damages from a cancellation were difficult to estimate at the time of contracting, and the $8,000 was reasonable. It's not punitive. The clause was negotiated in good faith, and the cancellation, which equals the breach of the contract, is exactly the type of event that this sort of clause would contemplate. Harbor Roasters would then pay $8,000 in liquidated damages. Now, in other lectures, we've already covered mitigation of damages, but we need to go through it again here because we're in damages section. The topic is damages. So in contract law, mitigation of damages is called the duty to mitigate. And this duty requires the non-breaching party to take reasonable steps to reduce the losses caused by the other party's breach. But it doesn't require any kind of heroic efforts or risky actions or major financial sacrifices be made. It simply requires reasonable, good faith efforts that a prudent person would take under similar circumstances. If the non-breaching party fails to mitigate, they cannot recover the portion of damages that could have been avoided with reasonable efforts. So the key principles here are the duty arises after the breach, and the non-breaching party must act reasonably, not perfectly, and the breaching party bears the burden of proving a failure to mitigate. And damages are reduced only by the amount that could have been reasonably avoided. So a scenario, a company, Suncoast Events, hires Chef Martinez Catering to provide food for a 200-person corporate banquet at a price of $12,000. But 2 days before the event, Suncoast cancels the contract and has no justification for doing so. But Chef Martinez has already purchased $3,000 worth of perishable ingredients, scheduled some staff to help that day, reserved some rental equipment and tables, etc. And instead of attempting to resell the food, offers discounted meals or book a replacement event. Instead of doing that sort of thing, Chef Martinez simply throws away the ingredients and seeks the full $12,000 in damages. Well, direct damages for the breach it has some. He can recover direct damages for the breach, and there are some unavoidable losses, such as any ingredients that truly could not be resold or repurposed. but the court will reduce the damages by the amount Chef Martinez could have reasonably avoided if he had sold the ingredients to another caterer, offered a pop-up dinner special, used the ingredients for other upcoming events. But because the chef made no effort to mitigate, the recoverable damages will be reduced accordingly. Next, we'll go into equitable remedies. Excuse me. So, equitable remedies prevent unfairness and unjust enrichment. And equitable remedies can include injunctions, like specific performance, or I should say injunctions, the requirement of performance called specific performance, rescission, and rectification to uphold the fairness. So an equitable remedy, such as injunctions, highlighted here, this is a classic situation where money damages are inadequate, so the court can order a party to do or stop doing something instead. And injunctions can be permanent or temporary. So here's a well-known violinist, Elena Marquez, signs a 1-year exclusive performance contract with Symphony Hall Productions. And under the agreement, Elena agrees she'll perform only for Symphony Hall during the contract term. She won't perform for any competing venue within 100 miles. And Symphony Hall invests heavily in marketing, printing posters, selling the season tickets, based on her name. And halfway through the season, Elena receives a more lucrative offer from a rival venue called Grand Arts Theater and announces she'll begin performing there immediately. And so, of course, Symphony Hall sues her for breach of contract. So money damages in a situation like this are not adequate. They can't easily calculate the exact financial loss that they would incur from lost ticket sales, reputation damage, refunding to season ticket holders, etc. And Elena's unique talent means that Symphony Hall simply can't replace her with another performer. So the court cannot force Elena to perform because, remember, specific performance is not available for personal services types of contracts. But it can issue a negative injunction where Elena is prohibited from performing for Grand Arts Theater or any competing venue for the remainder of the contract term. So this prevents her from violating the exclusivity clause and protects Symphony Hall's contractual rights. So Elena is not forced to work because we can't do that for personal service contracts. But she can't work for the competitor either. And the injunction will preserve the benefit of the bargain for Symphony Hall, and money damage may still be awarded, but the injunction is the key remedy here. Next, we'll go into specific performance, and it's in a sales contract. The classic remedy is, this is classic when the unique goods come into play. And in those cases, money damages simply won't make the buyer whole. Recall that specific performance, again, is not allowed with personal service contracts. And so we have a situation next, an example. A collector, Ms. Davenport, enters into a written contract with Heritage Antiques to purchase a 1902 Steinway Model B piano that once belonged to a famous composer. And the piano is one of a kind, historically significant. It appraises at $180,000, and it's impossible to replace it on the open market. At the contract negotiation, the parties agree on a purchase price of $175,000 with delivery scheduled for June 1. And 2 weeks before delivery, the antique dealer receives a higher offer of $225,000 from a different buyer. So they cancel their contract with Ms. Davenport and they attempt to sell that piano to the higher bidder. So Ms. Davenport sues for specific performance. And why is that? Because money damages are inadequate. Given the uniqueness of the piano, its historic provenance, it can't be duplicated. And even if Ms. Davenport received money damages, she can't buy an equivalent piano anywhere. So UCC Article 2 allows specific performance when goods are unique or in other proper circumstances. So a court can order specific performance requiring Heritage Antiques to deliver the exact piano to Ms. Davenport as promised. And then, the seller cannot substitute another piano or simply pay damages because the essence of the bargain was the unique item itself. So this scenario highlights the UCC's rule that specific performance is available for unique goods. It contrasts also, again, reminding us that personal services contracts contrast with the situation because it's can't have a personal services where specific performance is not allowed. All right, next we're going to go into rescission, restitution, and burden. When fulfilling a contract becomes excessively burdensome, one party may seek rescission to relieve obligations. And rescission is when a court undoes a contract to protect a party from unfair obligations, hardship, or inequitable circumstances. Some of the classic grounds include misrepresentation, unequal bargaining power, and unfair hardship. So we have an elderly homeowner scenario here, and he's 82 years old, Mr. Thompson, and he lives alone, has limited vision, and after a storm, a minor storm, a roofing company called Sky Shield Roofing knocks on his door and tells him his roof is in immediate danger of collapse. This is false. The roof has only minor cosmetic damage. And the salesperson pressures Mr. Thompson to sign a same-day contract for a full roof replacement, which is costing $38,000. And this amount just so happens to be more than double the market price and far beyond what Mr. Thompson's income permits. Then they back it with a financing agreement with 19% interest rate, with a 19% interest rate. And the salesperson has an assurance, don't worry, Mr. Thompson, your insurance will cover everything, which is also false. And the insurance company later denies the claim because the roof did not need replacement. So when Sky Shield begins demanding payment, Mr. Thompson seeks legal help. And the court can review the circumstances and might find material misrepresentation because the salesperson lied about the roof's condition, unfair persuasion because high-pressure tactics on that poor, vulnerable Mr. Thompson, who's elderly and has some health problems. And substantive unfairness is in play. The price and financing terms are grossly excessive. There's a severe hardship put on Mr. Thompson. He can barely afford to pay his basic living expenses, but now he's got a contract form that was through misrepresentation and unfair dealing. And enforcing it would impose extreme hardship on Mr. Thompson. So the court can undo the contract and the court can order rescission. And it treats it as if the contract never exists, voids the financing agreement, requires Sky Shield to return any payments already made and after placing that lien on the home, and prevents and makes sure the lien gets lifted. And so Mr. Thompson is restored to his pre-contract position, and the company cannot enforce unfair obligations. So that we need to go into the next scenario because rescission doesn't just cancel the contract, it restores both parties to their pre-contract positions. So this one involves a defective solar panel. Ms. Rivera signed a contract with Bright Sun Solar to purchase and install $22,000 rooftop solar system. And here's where the salesperson tells her the panels qualify for a special state rebate, and they don't. Her roof is fully compatible. It is not. The system will cut her electric bill by 70%, and there's no evidence for this. So she relies on these statements and signs the contract and pays a $5,000 deposit. Then a city inspector shows up after installation and halts the project because the panels are not approved for her roof type. The installation violates local code. The rebate program never existed. And for these reasons, Ms. Rivera decides to sue for rescission based on material representation. So the court's decision could be to rescind the contract, finding the salesperson made material misrepresentations, that she reasonably relied on them, and enforcing that contract would cause unfair hardship. And so the court could rescind it and treat the contract as if it never existed. So remember, there's that restoration to the original position of the parties that comes along with rescission. And to restore them both, Brightson's going to have to give the $5,000 deposit back and remove all the equipment at its own expense, repair any damage caused by the partial installation. And then Ms. Rivera must return that equipment left on the, anything they left on the property, and then provide access to remove it. And the end game is both parties are placed back in the position they were in before the contract was formed. And Ms. Rivera gets her money back, her home is restored, Brightson gets the equipment back, doesn't receive any payment, and that's because the contract is voided. And this is what the essence of rescission is, which is to unwind the deal, eliminate the obligations. Next, we'll talk about reformation, which includes accord and satisfaction and contract modification. So reformation is through the court, where the court orders a change to contract terms without nullifying the contract, unlike rescission. It involves adjusting contractual obligations through mutual agreement or court intervention. And modification means the contract remains in effect, but with different amended terms, as decided by the court. Quasi-contractual remedies are also interesting, so we'll talk about those next. So I couldn't help but choose a famous divorce case out of California to talk about the quasi-contract concept, which is where no formal contract exists, but fairness requires a remedy. And coupled with that, there's undue enrichment, and one party receives benefits that are unfair at another person's expense, which is what triggers the quasi-contract remedy. So the famous case of Marvin versus Marvin is actually the case that this was back in, in 1976, a California case, where the term palimony actually was coined. So this was an actor, Lee Marvin, lived with a Michelle Triola Marvin in a long-term non-marital relationship. It's kind of hard to see this as non-marital when you see Marvin versus Marvin. Usually when you see that type of thing, it's a marital gone bust. But they weren't married. But Michelle, they got on the rocks, and Michelle claimed, and they're splitting up, but Michelle claimed that they had an oral agreement that she would give up her career to support him, and that they would share earnings and property, and he would provide lifelong financial support. But after the relationship ended, she had to sue for support and property division. And the legal issue was, can unmarried cohabitants enforce agreements, express or implied, regarding property sharing or financial support? The California Supreme Court held yes, that they can. And they point out that express contracts between unmarried partners are enforceable unless they're based on sexual services. And if no express contract exists, the court may consider implied in fact agreements based on conduct. If neither type of contract can be proven, the courts can still award equitable remedies, including quantum meruit or other quasi-contractual relief, to prevent unjust enrichment. So Michelle ultimately did not prove that there was an express or implied contract, but the case established the legal framework, as I pointed out already, for palimony claims. So how does this relate to quasi-contractual remedies? It's a cornerstone for understanding quasi-contract, which is implied in law obligations, and they operate when no enforceable contract exists. And it recognizes, the court explicitly held that even if no express agreement exists and no implied in fact contract can be proven, a partner may still recover under quasi-contract to prevent unjust enrichment, and opens the doors to remedies such as quantum meruit, which is the reasonable value of services, constructive trusts, equitable liens. That's one. It also helps us distinguish contract from quasi-contract, because the court drew a clear line in Marvin versus Marvin that contract remedies enforce the parties' actual agreement, and quasi-contract remedies impose obligations even without an agreement, solely to avoid unfair benefit. And this is a classic restitution doctrine. Another thing that Marvin versus Marvin showed up with was application to cohabitation. So the court recognized that long-term cohabitation can involve things like shared labor, homemaking, career sacrifices, and contributions to earning capacity. If one partner walks away with all the economic benefit, quasi-contract allows the other to recover the reasonable value of contributions. Now, also important is in the family law world, as far as marital contracts, premarital contracts, etc., the court reaffirmed something very important to these types of contracts, and that's meretricious consideration. So the court reaffirmed that quasi-contract cannot compensate for services that are inseparably linked to sexual relationships. That's the meretricious. That's what that means. And so that's going to preserve the public policy boundary that is discussed in family law matters with regard to premarital, postmarital, etc. types of agreements. So it's a landmark case, Marvin is, for quasi-contract, because it modernized restitution in domestic relationships, and it confirmed that the court can use equity to fill gaps where traditional contract doctrine fails. Created a framework for palimony claims grounded in unjust enrichment, not marriage law, and it's now a staple example of how quasi-contract protects reliance and prevents exploitation. So what you just got in that slide, or that little piece of the talk, was both a contract lecture and a family law lecture. All right, so we'll look at quantum meruit a little bit more closely now. We did see that in the Marvin versus Marvin case. But I want to show you the difference between quantum meruit and quantum valabant. Now, I was not sure how to pronounce that name, V-A-L-E-B-A-N-T, and it felt like, wow, what if my students hear me pronounce this incorrectly? And so I looked it up in Webster's, and it didn't show up. It's a Latin term, and it kind of surprised me it's not there. It's actually valabant, excuse me. And I would like to just help you remember that term by thinking it's valet. The car, you go to a restaurant, you might valet park. Valabant. So there you go with some fun stuff. So quantum merit refers to the value of services provided when payment is not made. Let's go back to our situation with Marvin. What was the value of what she provided to him? Quitting her job, becoming a housekeeper, helping him with business, the acting. So let's first look at quantum valabant. And as much as what it says it's for goods, by the way, it involves goods, not services, all right? And that's what the importance of the difference between valabant and merit is. And as what the quantum valabant says is as much as they were worth. As much as the goods, were worth. And provides restitution for the reasonable value of goods. So we'll use a scenario here for the produce mix-up at a local restaurant where Sunrise Bistro calls its supplier, Greenfield Produce, and says, "We're slammed today. Can you send over your usual assortment of vegetables? We'll settle up later." No price is discussed. No written contract is made. So we don't have an express contract, do we? And we didn't discuss a price. So Greenfield says, "Here you go. Here's your produce," brings it over. But Sunrise Bistro takes it and uses it during its lunch service, gets all of its benefits from it, and Greenfield sends them an invoice for $180 that they refuse to pay, claiming we never agreed on a price. Well, because the restaurant accepted and used the goods, Greenfields can recover the reasonable market value of the produce under quantum valabant. I got it, sorry. That is an example of quantum. We could say quantum physics instead of quantum valabant. But anyway, I hope you're enjoying my little kind of corny crack-ups. This is my last vid of this playlist, and I'm grateful. All right, now let's look at quantum merit, because that has to do with services, so scenarios involving services. And so now we're going to change that definition in English to as much as he deserved. That's a type of restitution that comes along with reasonable value of, again, services. So Mr. Alvarez wakes up to find a fallen tree branch has broken her back door. I don't know if I said Mr. or Ms., but it's Ms., obviously, in this case. I should say their back door. They call local carpenter, Ridgeway Repairs, and ask, "Please come fix this as soon as you can. I don't care about the price right now. Just make the house secure." So in comes the carpenter, got there within an hour, removes the branch, replaces the shattered door panel, installs temporary reinforcement. And Ms. Alvarez thanks them and signs the work order acknowledging completion. And then Ridgeway Repairs sends a bill for $350 that Ms. Alvarez refuses to pay, saying, "We never agreed on a price, so I owe nothing." Well, sorry, Ms. Alvarez, because the carpenter provided necessary services at the homeowner's request, and she accepted the benefit, the law requires her to pay the value of the services under quantum merit. So I hope the two gave you an example of the structure of the different subject matter, goods versus services, and neither had agreed upon price, so that's one example, and also that there are implied in law obligations that prevent unjust enrichment of others. All right, last section, I believe, is waivers and their effect. This might be one other section, I can't remember. So waiver of breach and consequences. So waiver is the voluntary relinquishment of a known right, such as the right to sue for breach. If the innocent party waives the breach, they lose the right to sue for breach of contract. A waiver is the forgiveness granted by one party when the other party fails to meet contractual obligations. An express waiver is clearly communicated, either verbally or in writing, indicating forgiveness of the breach. For example, when an attorney receives a settlement offer for an auto negligence case, if the client takes the money for the settlement, they must sign a waiver or release of liability of the insurance for the insurance company's enjoyment. The client can no longer sue the insurance company, and this is an express waiver. An implied waiver is inferred from actions or circumstances showing acceptance of the breach without formal declaration. Late rent payment scenario is a good one here. A commercial tenant. Now we're still in Harbor because I live near the water. Harbor Fitness leases space from Bayfront property. So it's a commercial space, fitness center, and a strip mall or something Bayfront owns or manages. The lease states rent is due on the 1st of each month, and any payment received after the 5th will result in a $250 late fee for the first 6 months. And for the first 6 months, Harbor Fitness consistently pays rent between the 7th and the 10th of each month, and each time they accept the late payment without any objection. They put the checks in the bank the same day, and they never charge the $250 late fee. They don't send a warning either, or what we call a reservation of rights notice. In month 7, Harbor Fitness again pays on the 8th, and this time Bayfront says suddenly and makes a demand for the $250 late fee and all the late fees for the prior 6 months. Well, Harbor Fitness refuses, arguing that Bayfront impliedly waived the right to enforce the late fee provision. And the court would likely find that they did impliedly waive the late fee clause because they knew the payments were late. They consistently accepted late payments. They never enforced their late fee provision. Just out of the blue, on the 7th month, they decided to do that. And their conduct would lead a reasonable tenant to believe the landlord was not insisting on strict compliance with that clause. And waiver doesn't require a written statement, so know that. That's why this isn't implied. It can arise from intentional conduct that's inconsistent with enforcing a known right. So Bayfront's behavior signaled that late fees would not be charged, and they cannot retroactively enforce them without first having given clear notice that they intend to enforce the clause going forward. Another interesting story. And so we conclude, this is a variety of remedies we have available. We have different types, both equitable and legal remedies. And understanding remedies will help us do a better job of representing people or helping our attorneys represent people who are getting into a contract, and also help us to resolve disputes that incur as a result of contractual matters. Thank you. I hope you got some good information from this video lecture. Don't forget that I have a Teachable school account. Here is the address for that, mayananda-s-school.teachable.com. The name of my school is Mayananda. And also there's a coupon here for you to save some money. And finally, good luck on the exam. And don't forget to like, share, and subscribe.